Welcome to the WorkComp News and Views podcast, sponsored by Schlossberg and Umholtz, your go-to source for insights, strategies, and the latest updates in workers' compensation. Whether you're new to the field or a seasoned professional, we've got something for you. Don't forget to like, share, and subscribe, and/or leave a comment. And now it's time to sit back, relax, and enjoy the WorkComp News and Views podcast, sponsored by Schlossberg and Umholtz. And good morning, good afternoon, and good evening, whenever you are listening to us, and welcome to another edition of WorkComp News and Views, sponsored by Schlossberg and Umholtz. My name is Steve Appell. I'm a hearing representative with the firm, and please like, share, and subscribe. Well, what else can be said except applicant attorneys are the lifeblood of this business? Well, maybe 50-50. Defense attorneys, adjusters, injured workers are there too. But it's I was very happy to be able to get my brother, applicant attorney Marc Appell. He's a sole proprietor still after about 30 years. And my protege, who I also do the Workers' Rights radio show with on Sunday mornings in Southern California, attorney Robert Ozeran. 10 years, and he has made a name for himself. So without further ado, here's part two of my two-part interview dealing with applicant attorneys with attorney Marc Appell and attorney Robert Ozeran. Gentlemen, something that every defense attorney and every applicant attorney wants to hear: 5710 fees. Robert, why don't you take a moment and talk about 5710 fees?
Well, it's the lifeblood of the business. What can I say? It's what keeps the doors open and the lights on. No other way around it. The attorney fee for workers' comp is 15% on a contingency. This is the lowest attorney fee in any area of law across the entire United States, and it's on contingency. So I have to win. And it's just, the bigger cases, you may make a good amount of money. I've settled a case for $300,000 and my attorney fee will be $45,000. But that case took 4 years to settle. And the cases that are $10,000, if you were to settle those without a deposition fee attached, you could not sustain the advertising it took to take the case on. You couldn't pay. You couldn't get the case because to advertise costs money. To sign up the client costs time and money for wages, to print out the papers and the postage, and to work on the files, and to pay wages for people later to work on the files. All of this, if I was just going to settle a case for $10,000 and get $1,500 attorney fee, I'd go out of business. But defense attorneys know that. And they'll always try to say, well, why don't we get a deposition on calendar? And even if it's only $1,000, $1,500, usually it's like 3 hours for $400, $1,200. At least then my attorney fee turns from $1,500 to $2,700. And while that's very modest, that is the majority of workers' comp cases, things like that. When you do volume, that's how the most average case. What's the mode, the most common number? That's what would happen. Now, it may not be the average because you may have settlements that are $300,000, which is great. But for every $300,000 settlement that you have, you've had 100 cases at 10 grand. Right? So, and you couldn't sustain all the payroll, all the overhead, all the advertisements if you were going to settle 100 cases at 10 grand and pay for the advertising and everything associated with that.
Mark,
so
go ahead, Robert.
Lifeblood.
Yeah, Mark, what are your thoughts on 5710 fees?
Just exactly what Robert said. 5710 fees are an extremely important part of this entire cycle, and you always get paid on 5710 fees, and you'll get paid within a certain amount of time. You cannot know when you're going to get paid on a settlement on any case, and even though you have an idea, you can't know how much you are going to get. And even then, a lot of it also depends, though, on where you practice. And I don't know what Robert's rate is at this point, and I don't know if that's something he wants to discuss, and he certainly doesn't have to. But different judges at different boards pay different rates on the 5710 fees. So I had a petition I had submitted to Van Nuys that was transferred out because Judge Kelly told me they're down 6 judges, and it went to LA, where I was asking for $525 and they cut me down to $450. And now, granted, $450 an hour is nothing to sneeze at, but 30-year attorney, it's worth $525 in Van Nuys now. So
The
I don't know what they're paying.
The length of the average deposition for a regular comp case is about 2 hours. The length of preparation is 1 hour. But then applicant attorneys have a tendency to throw in those other charges. Robert, do you want to talk about the associated charges in addition to prep time and depo time?
Of course, I've taken this case on recon, and I've got a decision back from the recon unit as to what is covered under Labor Code 5710 and what is not. And what is covered: production of documents in response to deposition notice, and review and signature of the deposition transcript. So those additional charges, they have added, I would say, 20 to 25% increase in my 5710 fee intake, my income from that. Oddly enough, when I found that out, it was from a judge. I was doing a walkthrough in Van Nuys, and should we name judges here, Steve? Would you want me to give names of which judge?
Well,
ordered this?
I would suggest you didn't. Mark just named a judge, but I wouldn't give names.
Okay, I was advised. I was doing a walkthrough, and I was advised by a judge. He said, "Why don't you billing for deposition document production? Look at the depo notice that you attached as an exhibit to your petition, because you have to attach the defendant's exhibit petition, right? Notice to your petition." And I said, "I didn't know you can do that." The judge advised me you could. And from then on, I started responding as much as I could, I mean, time permitting, as if it was a civil response, as in a civil discovery and demand for production of documents. You have to write out the list of the exhibits that you're attaching to the response and what number exhibit goes to which request, right? And sometimes we have a huge file, and their production request says something like, every file in your possession in relation to this applicant, regardless of what it is. And you're out there listing 150 exhibits, and then you send them a bill for 10 hours at $525 an hour, which is my current 2025 rate as well, Mark. So it's good to see we're on the same page. We didn't talk about it before. But that is a huge bill. It's a $5,000 bill, right? I get pushback on that all the time. And I went to trial with a judge, a different judge, who didn't tell me to do this, a different judge. And he disagreed with the first judge. And he said that this is not part of the 5710 fee. Well, I filed a petition for recon on that issue, and recon came back, and basically I lost the battle, but I won the war, which is that this judge at trial, even though my client testified that we did the deposition transcript together, we reviewed it, provided changes, all of that. My client also testified that he asked me questions generally about his case, which is, of course, and there's no chance that an applicant meets with his attorney and says, okay, we only discussed the deposition transcript, right? That's not possible. So the judge wrote two things. One, the judge wrote that it's not covered under Labor Code 5710, the activity. And two, that I didn't prove that I even did the activity. Well, recon came back, and this is a decision called Purvis-Cowens, Purviscowens. If you Google it and type up the word WCAB right after it, you'll see it come up from recon. And recon came back and said, well, if the judge says you didn't do the activity, you're going to get 0. But the activity itself is covered under Labor Code 5710. And since that time, number one, I will never have a 5710 fee trial in front of that specific judge, because I know how he is a very smart man and how he crafted his opinion in order to give himself an insurance policy on being wrong. And I told him he was wrong on it from the jump, because there was other case law that I cited called Lett v. Travelers, Lett, John Lett versus Travelers. And that was a case on the DIR website where insurance previously did not want to pay until the deposition transcript was reviewed and signed for anything. And that case, published by Recon, they came back and said, no, you have to pay piecemeal. So while previously defense counsel was arguing in that case that the deposition transcript is not over, the deposition process is not over until you sign and return the transcript, and they're not going to pay anything. Now they switched to telling me, well, now it's not part of the deposition process. We don't want to pay now that way. So they always figure out a reason they don't want to pay.
We'll get
Well,
we'll get to
so
we'll get to
yeah.
we'll get to the pushback in a moment. Mark, do you produce documents? Do you review the transcript with your clients, etc.?
I haven't. I'm thinking of doing it now. And Robert, I wasn't able to find that. If you could send me that recon, I'd appreciate it. I'd like to see that opinion.
Yeah.
I have never been one to bill for anything other than prep and depot time. And I honestly don't respond to the document requests, and I'm never asked about it in the depot. Because for me, and maybe this is again about being smaller, it's never been worth the fight to try and get it where judges don't want to give you additional monies. So, but it's definitely an interesting prospect, what Robert's talking about, which I'm going to look into.
I want to talk about pushback, and it can be 5710 fees, it can be settlements, it can be personalities. How do you guys, when you're talking to defense attorneys, keep your arguments focused on the facts and avoid the personal attacks, Robert?
Well, when you have a certain number of cases, it's much easier to sort of check out of any interpersonal problems, right? I don't have time simply to have a problem with you as a person. I don't care enough. I have 100 other people in this list right behind you. So you can give me attitude, you can give me praise. I honestly will forget about it within 3 minutes of the end of the phone call. I'll already be on to something else. I just hope that I document my file so I remember this person is not nice to deal with, right? So then I'll be ready for the next time before I check my notes prior to the next phone call or something of that nature. So I have had people who don't like me personally. I mean, not everyone, my mom says not everyone has good taste. So I assume that's what their issue is, that they don't know, a nice person when they see it. But I'm not concerned with being liked or anything like that. I'm concerned with bringing home money for myself and for my clients. And if I have to be the bad guy, if I have to be the heel, I will be. If I have to be the kind one, I will be. I will try my best to adapt to the stage that is presented in front of me in order to reach my goal. More of a chameleon than a certain personality type that is always the same at every juncture, even though I always want to appear reasonable.
Mark, how do you avoid escalating the personal conflict and keeping the arguments focused?
I typically end the call once the conversation starts. Once the conversation starts getting bad or the email gets nasty, I sort of do a little, my wife would say, call it a passive aggressive approach, and basically say, well, you're not letting me talk and you're clearly not interested in anything I have to say. So I'm just going to say we disagree. And that's that. At the end of the day, I think it circles back to what we talked about, where it's personalities. If you get along with people, you're going to get along with them. And if you don't get along with these people, it's best to try not to discuss. I say my point, and if they want to agree, they will. If they want to disagree with me respectfully, I'll talk with them. If it escalates, that's it. I'm done. Eventually you'll settle eventually, or you'll see him at a trial or whatever. But I don't have, like Robert, I don't have time to engage in this back and forth. Everybody wants to have the last word, but at the end of the day, it's just childish to go that direction. You'll never win.
And you know what? I actually was talking about this with one of my colleagues last night. So this is how topical this is. And when dealing with the defense attorney, this is something a judge told me. I don't want to say which judge, but there's a quote.
Thank you, Robert. Thank you.
It's about wrestling with a pig in not nice conditions. I don't want to curse, but it starts with the S word. Okay, wrestling with a pig in S. Even if you win, at the end you'll realize that the pig liked it. So
interesting.
You will never win an argument with the defense attorney because they get paid by the hour to sit there and argue with you. You have to get money on a contingency basis, and every moment you spend with them, whatever, a calorie of energy you burn arguing with them, you're not going to win them over. All right? You have to be respectful, of course, but you're not going to win them over. You just want to hear what they have to say in order for it to be a working relationship. I mean, I'm sure Mark knows this, but defense attorneys, they call you, and they're not bad or good. They're just in the middle. And they always have this preamble, this 10-minute speech of why they're going to offer you what they're going to offer you. And in reality, you don't care, right? You're sitting there respectfully going, yeah, oh, yeah. Are you saying it was post-termination? Gotcha, right? And then what you really want to know is just give me the number. I know your defenses. I saw your denial notice. I saw your answer in the application. I know what you're saying. I read your prior emails, right? So just give me the number. And then afterwards, if you want to discuss it with me and justify it, it's a little bit different. But you still want to be respectful, right? So you do listen. But again, you're not going to win a wrestling match with somebody who gets paid by the hour to sit there and wrestle with you.
That's great. Mark, we'll take a very short break before we go back to part two of my two-part interview, dealing with applicant attorneys. My name is Steve Appell. You're dialed into Work Comp News and Views, sponsored by Schlossberg and Umholtz. Please like, share, and subscribe. And I'm a hearing representative with the firm and just loving what I do. So we'll get back to dealing with applicant attorneys with my brother, Marc Appell, 30-year sole proprietor, and applicant attorney Robert Ozeran, 10-year extraordinaire. Let's talk for a moment about the current medical issues in workers' comp. You've been doing this for 30-some-odd years. Have the medical issues gotten more difficult or simplified? What are your thoughts?
Well, I think, first of all, it depends who you're asking. If you're asking a defense attorney, you're asking an applicant's attorney, you're asking a client, or you're asking a judge. We all know that UR is intentionally slanted in favor of the defense. You've got employees of the defense determining it. IMR, if there's any IMR people listening, no offense, but they pretty much rubber stamp almost all UR approvals, or denials, I should say. It's gotten, I think, less complicated because it's an easier process, but it's much more difficult for the applicant, and it wears them down. And I think it's a large part of why applicants choose to settle their cases earlier than they want to, for less money than they want to. But it's really taken away a lot of the fairness, I think. But so you have to sometimes look for technical glitches, like I'm waiting for a trial on an issue where I subbed in for another attorney, but they served the UR denial on his office instead of mine. I think that's an automatic win for me. But this utilization review is inherently unfair. Other than that, I think it's that's what comes to mind for me.
Mark, I'm sorry, Robert, what are your thoughts on the medical issues in workers' compensation?
I started 13 years ago where there was physicians all over the place willing to take the cases, psychological doctors on lien, internal medicine doctors on lien, urologists on lien, orthopedists and chiropractors everywhere. At this point, we have swung so far that there are no psychological doctors on lien that for any reasonable case, for any just standard workers' comp case. There are no internists who would take it on lien. I think Dr. Petrushka retired. He's not doing it anymore. And Dr. Curtis at Hamlin Psych Center closed down for the psychological stuff. Those were the big ones, right? It has gotten so difficult that you have to encourage your client to settle it and go and control their own medical care through a private health insurance company. And hopefully you can get them enough to put it in their pocket and they can buy health insurance and they could actually get well. If I was king for a day, if I was governor of California, one of my first executive orders or king orders would be to throw this whole system, the whole medical system, into the trash, including the fee schedule, including the lien filing fees, including the MPNs, everything, including the UR or RFA form, even the forms. Just no, because doctors are good at doing medicine. They're not so great at filling out forms and sending it to insurance and waiting for utilization to review to respond. And then they try to do that peer-to-peer, which is always just complete baloney because they never actually call each other, right? They'll never get each other on the phone. You'll see it in the notes there, left a message. It's the complete, and Mark is right. I think we did a story on the radio show that I do with you, Steve, aside, where we discussed, 90% of all IMR IMR, all UR denials are upheld by IMR.
Mm-hmm.
Some ridiculous number. Right? So at this point, what happens is defense counsel knows this. This is not a secret. They use it as a negotiation tactic, leverage. I have countless times heard defense attorneys say, do they really want to be stuck with IMR denying their treatments forever? Or UR denying their treatments? Why don't you just settle with me? Sure, it's not the full value, but it's better than what's the alternative. And you know what? They're right. They're not being disingenuous. They're not using inappropriate tactics. They're telling me the truth of what the system is like for injured workers. So California, while still being the best system in the country, to my knowledge, wow, we have really gone way too far on providing treatment to injured workers. And I understand that we're coming from a time where doctors were performing spinal fusions on lean for people who didn't need it. And that was the motivating reason for putting all of these regulations in. But that at this point, they have strangled the fraud with the patient, okay?
Mark, we've all had cases that unfortunately have gone south. When that happens, do you take 100% responsibility when you talk to your client and explain it? Or do you blame it on the defense counsel, blame it on the judge, maybe throw a little off on your secretary? Do you take full responsibility for everything that happens, especially when a case goes south and you got to talk to your client?
Well, I think Robert's going to agree with me. When a case goes south, it ain't our fault. First of all.
100%. I'm not the doctor.
No. I mean, usually when a case goes south, it's for one of
Oh,
two
I
reasons.
forgot. You
got a
blamed
bad
the doctor also. Sorry, I forgot that one. Yeah.
Well, that was where I was going to first go, because it's either the case is going to go south because you get a bad doctor's report, or your client has not been 100% honest, or there's some bad sub-row video. Typically, a case is not going to go south due to us unless we missed something, or there's been a long delay in doing something that has forced the client into a bad position where financially they have to settle quick. But again, I've always said, it's always been my opinion, and I don't want to cut down the skill of any lawyer, because there are certain lawyers that can definitely make cases more valuable. But I've always been of the opinion that for the most part, these cases are medically generated. Okay, you make sure the applicant is getting their benefits and make sure they're getting their treatment, and then the case should run itself. And because Robert touched on this, the way the system now has worked, the case is going to end in a QME final report, and then you try and make magic out of that report. It's very hard to screw up a comp case, in my opinion. There are ways to make it better, and the skillful ones definitely do it. Robert and myself can definitely make it better. It's very hard to make a case go south as an attorney.
Robert,
agree.
Robert, you have a large staff, and when a case goes south and you have to explain it to the client, do you take full responsibility or shuck some of it off to maybe one of your part of your team?
No. I love taking responsibility even for things that aren't my fault. Okay, I do. Problem is that in workers' comp cases, the lawyers, we really just kind of get you there. We don't write the medical reports. Right? We could overcome a bad report, but we're not going to be the one who publishes a bad report. You did that as the client with that doctor. And we can try to take a deposition, we can try to get a rebuttal report. But I think one of the easiest insurance policies to write is a malpractice insurance policy for a workers' comp attorney, because there's always a defense. It's just, well, you were not injured, here's a medical report, right? Or you weren't prejudiced, so what? If your applicant attorney missed the QME striking process and the other side elected, it's still a neutral doctor after all, right? It's just, there's not many ways to screw up. That's, by the way, the reason that I nearly exclusively do workers' comp. I've done some PI in the past. I have jury trial experience, and I enjoyed it. But if you make a mistake in personal injury, there could be fatal flaws, and the case is done. And you get thrown out. There's a statute of limitations. You can't refile, and you better be calling your malpractice insurance carrier. In workers' comp, I have never had a reason. I'm knocking on wood right now. But I've never had a reason to call my malpractice carrier. I've had people make some frivolous claims like you didn't file a 132A or an S&W in time, and you look at it and you go, well, you signed up with me 4 years after you last worked. So no, I didn't mess up, right? Or your facts simply don't meet those standards. It's a CT for carpal tunnel, right?
Guys,
It's very difficult to screw up.
Guys, we've only got a few minutes left. One last question. Both, and this is one of the reasons why I really wanted to have this interview. Both of you run your own show, hang your own shingle. You clearly don't work 40 hours a week. How do you manage your time, Mark? How do you manage your time?
Well, I'm in early. I'm not sure what you mean. Do you mean work or everything?
Do you have problems managing your business with your personal life?
Well, it's gotten easier since my kids have grown. They're finishing up college now, so that's taken away a lot of my. I tried to be a very involved dad when my kids were growing up, and that's probably another reason I didn't build my practice as much as I could, because I wanted the ability to go to everything that my kids were doing. It's easier now that they're grown. I mean, I'm usually in the office by 7:30 or 8. I try and get out by between 5 or 6. If I have things to do, I have to do. And then, because I don't have a boss, except the woman at home I'm married to, she's the boss.
Yep, of course.
I try not to take the work home with me. I'm one of the few lawyers, and this may be good or bad, I don't give the comp clients my cell. And I when I first got a cell 20 years ago, I said, only call me if this is an emergency. And Robert probably will understand this.
They all called.
Too. I learned very quickly it's always an emergency in comp, especially on the smaller ones. And I'd be getting calls at 11 o'clock at night on the weekend. Work is important, supporting your family is important, but you have to have a life. So as I've gotten older, I think unless I've got something that's urgent, when I leave, I leave. I may do something for 10 minutes, 15 minutes at home, but then I'm done. And I try and enjoy the personal time. And if I have to work I work on a weekend, especially for civil trials, it's different. But that's what I try.
Robert, really quickly, how do you manage your business life with your personal life when it comes to time constraints?
I'm jealous of what Mark's saying because
you work 80 to 100 hours a week, right? No.
I wouldn't even say that. I am always working if I am at home, and I am at home most of my day. Right? I might go out to eat. I might get dinner on a weekend, go on a family event, but I will always be at my desk. You will never catch me sitting on the couch. The couch is the least used piece of furniture in my house. It's brand new, actually. I purchased it and never sit on it. The dog sits on it a lot, but not me. And I am always on the clock. I agree with you, Mark, that you shouldn't be giving clients your cell phone. When I started my business, I was giving my clients my cell phone, and we're talking a decade later, and they've given it out to people, and then they've given it out to people, and I'm still getting phone calls and text messages on my personal phone. Luckily, the majority of my cases is through my advertising, and that's strict to the office, okay? I don't call my clients from my personal cell phone, and when I have to call them from the court, I block my number by doing *67. So I know exactly the issue Mark was referring to. Unfortunately, when your cell phone does get out, it's sneaky. It's hard to put the ketchup back into the bottle, right? The toothpaste back in the tube. But I'm always working on that. And in terms of balance, I personally schedule myself for things so I can leave my desk. I will go to the gym. I'll go to my friend's gym. I'll go to a family event. I'll go on a hike. I will schedule time. But when I am home on my own, 100% of the time I am at my desk. 100% of the time.
Attorney Robert Ozeran, applicant attorney practicing for 12 years, big mega firm. My brother Marc Appell practicing for 30 years, a sole practitioner. Gentlemen, thank you very much. I really appreciate your time.
Thanks, everybody.
Anytime, Steve.
And with that, we are done. Part 2 of 2 parts dealing with applicant attorneys. Much thanks to my brother Marc Appell and attorney Robert Ozeran. Thank you very much for listening to another edition of Work Comp News and Views, sponsored by Schlossberg and Umholtz. My name is Steve Appell. I'm a hearing rep with the firm. Please like, subscribe, share, and thank you very much for listening. You've been listening to the Work Comp News and Views podcast, sponsored by Schlossberg and Umholtz. The opinions expressed on Work Comp News and Views are for entertainment purposes only and not to be considered legal advice. Don't forget to like, share, and subscribe, and/or leave a comment. Also, feel free to send an email directly to sappell@schlossberglaw.com. For Work Comp News and Views and Schlossberg and Umholtz, my name is Steve Appell, and thanks for listening.